All right, welcome everyone to the Tuesday, July 8th, 2025 Tumwater City Council work session. And I believe we have all the council members. Councilmember Althauser is excused. He is not available this evening. So we will go to the first topic on our agenda, which is the land use training. And is Brad here to start?
Yes, I apologize. I had left Jeff to hang out by himself for a while, as Councilmember Dahlhoff had raised. I just want to again thank Jeff for coming in for this opportunity. I think it's always a good time to have a refresher on land use law and the various roles everyone plays as part of that process. I don't want to steal Jeff's thunder, but I think there's a couple important points that I just want to have you draw your attention to begin with, and that's the role of all this comp plan update process and our development code update as probably the best time for the council to be involved in land use areas. I also want to point out, again, a surprise at the very end of Jeff's thing that will be informing some of the work that we'll be doing at the later in this year that is a new thing, but I'm not going to steal that entirely. So Jeff, thank you very much for coming.
Okay. Well, it's always good to come to Tumwater's Council and talk about land use issues. It reminds me there is something other in life besides public records. But anyhow, it's been a few years, and some of you who have been on council a little longer may have seen some or all or remember parts of this presentation. I apologize if it's redundant for you, but want to just try to go over some of the fundamental legal principles that underlie land use regulation in terms of our Constitution and statutory basis. Talk about some of the pitfalls that can create legal liability. Talk about some of the issues that may be coming in front of Tumwater. And talk about whose responsibilities are there to go forward. I'm going to go ahead and start by sharing a PowerPoint presentation that we have worked up. And I hope everybody can see that okay.
Yes, we can see it.
Good. Just to start off with, I encourage people to interrupt and ask questions. I think that probably the most valuable use of our time is to try to address some of the questions you have as they come up through the course of the presentation. And if you get ahead of us because you're asking the burning question that I've tried to save for last, I'll let you know I'm going to deal with it later on. So don't be shy. Feel free to ask those questions. I want to start off by talking about why do we have land use regulations at all? And what are the reasons why we're talking about land use law and land use regulations? Because after all, there was a day in this country when people believed that it was your property and nobody could tell you what to do with it. Some people still believe that, and we run across them occasionally. But our law doesn't agree that you can't tell people what to do with their property. It says you can at certain times for good enough reasons. And land use planning and land use regulations are recognized as a legitimate exercise of the police power, the power to protect public health, safety, and welfare. And that is a core function of government under the Washington State Constitution. Cities like Tumwater are given very broad authority to make and enforce any laws which are appropriate in order to protect public health, safety, and welfare under the police power regulations. The only caveat that our Washington Constitution says is that you can't be in conflict with the general laws. That means if there's a state statute that tells you where you can and can't have homeless shelters, you have to follow the state statute when you are drafting your local regulations. That shouldn't come as any great surprise to council members. I said there was a day in which people thought that you couldn't be told what to do with your property, and it's about a century ago. A case started working its way up where a new form of land use regulation was at issue in our courts. And it was challenged by people who didn't think you could be told what to do with your property. And it was the case of Euclid versus Ambler Realty. The village of Euclid is a suburb of Cleveland, and they adopted something which has now come to be known as Euclidean zoning. Euclidean zoning was a series of zoning districts in which each district was progressively more restrictive, so that if you were in the U1, use restriction number 1, the only thing that you were allowed to do with your property was to have a single family housing on it. U2 would expand that to allow single family plus duplexes, and U3 added multifamily. U4 added additional commercial uses. U5 had some light industrial, and then U6 was virtually unlimited. You got to do any of those other things, plus you got to do more heavy industrial uses. And they drew a map and they said, these are the areas that we want to have these various districts apply. And then it had some uses which, like a slaughterhouse, was prohibited throughout the city. And the certain businesses said that they did not want to have their property restricted. They wanted to be able to use it for commercial, but they could only put in multifamily and residential uses. And so they thought that that interfered with their constitutional property rights. It violated the Constitution, and they took the position that private property rights trump community values. So they sued, and the Supreme Court in the landmark case of Euclid versus Ambler Realty said, no, you are allowed to zone and restrict the private use of property in order to promote the public's interest, and that the community values and protection of public health and safety were legitimate reasons to regulate, unless the regulations themselves were arbitrary and irrational. So the use and the height and the area restrictions that were adopted as Euclidean zoning were allowed. And this is a quote that came out of that case as to explaining the rationale for why we have land use regulations. It talked about the modernization of society, and you think back in the Midwest in the late 19th century and the early 20th century, it was a place of great industrial growth. Steel mills were flourishing. We really had an expansion of population, concentration of urbanization that really created some conditions that government needed to step in order to benefit the entire society. And you'll see that the court said that some of these regulations might have been viewed as arbitrary and oppressive, but today they are sustained under the complex conditions under which we live. Because of the use of automobiles, of rapid transit, streetcars, all of these things in society as we grow require us to balance where and how things are appropriate. And that should sound really familiar, because the same concepts that underlie Euclidean zoning as the answer in 1926 underlie the Growth Management Act.
You need to come up here?
Yes.
Councilmember Kathy has a question, it looks like.
Joan, please.
Hey, thanks,
Well,
Jeff.
come on up. Come on. Kelly, come on.
Somebody has their microphone on.
I'll start
Go ahead,
over.
Joan.
Yeah, I don't need to jump up. It's a simple question. One thing I want to know, you said that the land use has to do with health, safety, and what?
And welfare,
Welfare.
promoting the public welfare. That's
Okay,
the core of the police powers under Article 11, Section 11 of our state constitution.
okay. So,
Protecting the environment being one example of protecting public welfare, not just health and safety, or human health and safety. It's more broad than that.
okay, so some of the things that we have on our, in our, rules and regulations and so forth, they need to fit into one of these if we were going, let me just give you an example. Does the health of the change, and especially now when we're in this climate crisis, so forth, so could it impede our health if someone were to violate our tree code and take down trees because we need more housing? Or how would we get into that kind of?
I think that is the legal basis for adopting a tree code when you're developing, for adopting any of the development regulations that we have, is that it promotes the public good, the public welfare, in order to have tree preservation requirements, mitigation requirements when trees are taken down, and to have those laws, and I think we started off in 1926 with this sort of very simplistic concept of Euclidean zoning. And we've gotten a lot more sophisticated as we get into the Growth Management Act, and what we're required to plan and how we're required to plan. But the essence of why we are allowed to do that remains the police power of protecting public health and safety and promoting the general welfare. And that's part of the preamble of our federal constitution, is to protect the general welfare. So these concepts, I think, underlie both our federal constitution and our state constitution.
And then in essence, our city codes.
And your city code implements those fundamental purposes and the Article 11, Section 11 authorizes you to adopt whatever laws protect public health and safety and the welfare as part of that police power, unless it's in conflict with the general laws, or unless it violates some of the constitutional principles that we're going to talk about now, like due process.
Okay.
Due process has.
Thank you for that.
Due process has a couple of different elements to it. The one that was used back in the 1920s, I got to preface that because we're halfway through the 2020s. The legal principle that was used back then was something called substantive due process. You did not have a right to deny somebody the use of their property without due process under the Constitution. And substantive due process said, we're going to closely scrutinize any regulation, and you better have a really, really good reason to adopt it. Euclid versus Ambler Realty was a step in the opposite direction, that no, we need to value our community and we need to adopt laws which promote the community benefit more broadly. We still have some substantive due process requirements. Laws can't be so vague that people don't know what they mean. We always want to write our codes as clearly and precisely as possible so that people know how to comply. And furthermore, there is a requirement that there has to be a rational basis for our ordinances. We can't regulate things that are imaginary problems or which have no legitimate underlying basis. But that's a pretty low bar to meet under the substantive due process test. There is also a procedural component. And this is one where Tumwater has chosen to go down the hearing examiner path in order to provide procedural due process when we impose land use restrictions on someone. And that means that we're providing them procedural due process, notice, and an opportunity to be heard. If somebody is violating our code, we give them a notice of violation, and that's appealable to the hearing examiner, an opportunity to be heard. That sort of underlies all of the requirements that you are imposing, and it's why you have so many different appeals and why the lawyers get paid so much. Then there is, in addition to the due process clause, there is another part of our 14th Amendment and our 5th Amendment that talks about not allow private property to be taken for public use. And the takings clause of our Constitution does not prohibit you from taking the property. It just requires that you pay just compensation. It's really a feature of what is known as eminent domain power. And you have the power to take property for putting in streets. You have the power to take property for a valid public purpose. But normally you have to pay when you take somebody's property, you have to pay for the privilege of doing so. There are certain things where regulations can be so onerous that they constitute a taking of somebody's property. In the Lucas versus South Carolina Coastal Council case, these were regulations that were adopted after Hurricane Hugo came sweeping through in the late 80s. And the regulations were that basically on the coastal islands outside South Carolina, you couldn't develop your property at all. The only use you could make was passive recreational use. Well, people had paid hundreds of thousands of dollars for lots that were now essentially valueless. And the court said that if you take all the economic value out of somebody's property because of your regulation, that constitutes a taking and you owe compensation for that. Likewise, if your regulations require somebody to permit a physical invasion of their property, that constitutes a taking. And the Loretto case was a regulation in New York City where building owners had to allow cable access to be installed in their building. It was a physical invasion that they had to permit. And that took one of the bundle of sticks in the bundle of property rights that they have. And the court said that that constitutes a taking and you have to pay for the privilege of allowing cable installation. Most federal cases that deal with the takings clause are regulatory takings where the court tries to determine how far is too far. And the Penn Central case is one where there was a historic preservation law. And the court was trying to decide, does the regulations that are trying to safeguard Grand Central Station in New York City, does it go too far? Does it take the property? And the court said, we're going to evaluate it with a three-part test because whether it goes too far is just not a standard that can be applied in cases uniformly. So they developed the three-part test that you see here. We're going to take into account the economic impact on a particular piece of property. Does it take most of the value or only some of the value? To what extent does the regulation interfere with legitimate expectations to use property and interfere with legitimate investment-backed expectations? And then to what extent has the government used a means which is necessary to achieve an important public objective? And the more important the public objective, the more the government can regulate without fear of invading the takings clause. And so that is takings in a general sense. And then in the land use context, land use regulations often require people to set aside their property in order to serve some public function. When somebody files a plat, they have to set aside part of that development in order to serve public utilities, part of it to serve street purposes, part of it for sidewalks, part of it for parks, all of which serve the greater good of the community. When does that go too far and constitute a taking? And we have a couple of cases that came out in the 80s and 90s, the Nolan versus California Coastal Commission case and the Dolan versus City of Tigard. And they developed what's known as the nexus proportionality test. And that's a mouthful, and lawyers love that. But what it essentially means is there has to be a connection between why you're requiring somebody to dedicate part of their property and an impact that is created by the development proposal. A connection. In the Nolan versus California Coastal Commission case, somebody wanted to remodel one of their houses, and the Coastal Commission said, you know, your property is sitting right there on the shore. We need more access to the beach. We want you to dedicate an easement over part of your property, even though there was no connection between what they wanted a permit for and the problem that was caused of access to the beach. And the court said, well, there's no essential nexus between this requirement to dedicate that easement and the problem that's trying to be solved. So it violated the essential nexus test. Dolan versus City of Tigard was a case in which somebody was putting in a bike shop in the city of Tigard in Oregon. And the city said, we have a trail network and your development is going to generate additional trips and the need for public trails. So we want you to dedicate this several 100-foot long strip of your property for a bike trail. And the court said the particular development that they have doesn't justify taking hundreds of feet for a bike trail because it was only contributing a very small impact and need for that bike trail. And so the court thought it wasn't roughly proportionate between the dedication that was required and the impacts that were causing the need for that. And so the court said that violates what's known as rough proportionality. And the court said there's no magic formula. We're just going to spitball it and say if it's grossly in excess, that violates the rough proportionality test. Developers have for years argued that whatever they don't like violates the nexus proportionality test. It is still one of their preeminent arguments. And usually what we try to do is figure out some way, well, perhaps they don't want to dedicate their property. They might want to contribute to a community fund and we'll put in a community park somewhere else, but they've contributed to it with a fee in lieu of dedication or in lieu of mitigation. And the court said in the Kuntz versus St. John's River Management District that the essential nexus and rough proportionality would apply to these monetary exactions in lieu of mitigation or in lieu of a dedication requirement. So if you're requiring somebody to pay simply because they are creating impacts, you have to apply this nexus and proportionality concept. Last year, that got expanded to a new arena in the Sheets versus County of El Dorado case coming out of California. You are authorized to impose certain impact fees on development. And California had one where there was, and it says $23. It was a $23,000 fee imposed as a condition for a simple land use permit to remodel an existing home on an existing piece of property. And they wanted $23,000 for traffic impact fees. The Supreme Court said that that went too far and it violated the Nolan-Dolan test. And this was the first time that the Nolan-Dolan test was applied to a legislatively enacted development fee, like the traffic impact fee at issue in the Sheets case. So that means that the development fees that you adopt under Growth Management Act are potentially subject to review under the Nolan-Dolan test. And that really changed the law about a year ago. So in Washington, we have really tried to refine this whole substantive due process test. And the Guimont versus Clark case was one which dealt with fees that were charged to people who were converting mobile home parks. And the owners of those parks argued that the fees, which were intended to promote tenant relocation assistance, the question was, what's the test that we evaluate? And the court adopted a means and purpose test. It first of all looked at whether or not there is a legitimate public purpose, whether you are using a reasonable means to achieve that purpose. So means must be appropriate to achieve a legitimate public end. And then our Washington Supreme Court wouldn't just leave it at that, because that really is the federal test. They added a whole new layer, and they said, we're going to look to see whether the regulation is unduly oppressive on the landowner. And Guimont and some cases that followed it articulated a bunch of different factors to try to determine if the regulation went too far or was unduly oppressive. Well, thank goodness in 2019, we got rid of the unduly oppressive part of the test. And we went back to just determining whether or not the law is rationally related to a legitimate state or legitimate public interest. And so that's what substantive due process is going to look for. And that's a whole lot easier than trying to figure out this old unduly oppressive test. We also have in our Constitution the concept of equal protection. And that is that similar types of problems, similar types of proposals in similar situations are regulated the same way. If we want to distinguish and classify things differently, the Equal Protection Clause requires us to have at least a rational basis to impose these different classifications or to treat things differently. We think this problem is a little different than that problem, so we're going to make different rules for those. You, as the legislative body, get to figure out whether there's a rational basis to have those different classifications or to adopt different rules for different situations. That is limited in some situations where you are imposing things on what's called a suspect classification, where you are invading fundamental constitutional rights, or whether you are regulating things that are a protected classification like race or gender. And in those cases, the courts adopt a higher scrutiny. The highest of those is what's called strict scrutiny. And that is that you have a compelling public purpose that requires you to use one of these strict scrutiny types of classifications. it requires you to use a gender classification or a racial classification. Gender tends to come down a little bit and get a little less scrutiny. Washington, I think, if you're going to regulate on the basis of gender, you better have a darn good reason in Washington under the Washington Equal Protection Clause. But it also applies to other types of values like our First Amendment values. And this is particularly at issue when you're dealing with churches and the regulation of religious activity and speech. And we have seen in recent years that the ability to regulate someone's activity that is religious in nature is limited. There's a federal statute that gives a damages remedy if your regulations unduly burden their religious practices. This has been an issue in Tumwater, where we had people who asserted that they have a right to distribute food to the needy in a residential zone. And the trend lately has been toward protecting the rights of religious people to do what would otherwise be prohibited because it's motivated by religious motivations. And there have been a couple of cases lately. There was one that came out at the end of June in Wisconsin that talked about religious exemptions and pulling your children out of certain instructional programs because it offended your religious beliefs concerning reading of books that had LGBTQ themes. And our Supreme Court is right now at the federal level very clearly on the side of religious institutions. Adult entertainment regulations used to be a place where this was at issue. I don't know how that would be treated by our current Supreme Court, but certainly regulating things which are arguably free expression is going to be more difficult, and is something that may be treated with heightened scrutiny by our courts. I want to talk a little bit now about a situation where Tumwater made a difference in how land use regulations are used, and in an example, I think, where our courts tried to look to see how these constitutional principles apply to a Tumwater regulation. In 2012, the Ninth Circuit issued a decision about Tumwater's comprehensive plan and zoning regulations that establish a manufactured housing park zone. You have a zone which essentially the only use that you can use is as a manufactured home park. And you applied that zone to the existing manufactured home parks within Tumwater. The Laurel Park community, the Velcomin community, and one other that is out on Trosper, all sued, claiming that that was a violation of their property rights. It was a regulatory taking under the Penn Central case that we looked at earlier. We went through and we showed that there was a potential impact on property values up to about 15%, because there was some value in the future ability to convert to some other commercial use or more valuable use. But none of the property owners had an actual expectation that they were going to do that in any certain time frame. So it did not interfere with their investment-backed expectations. They bought the property to use as a manufactured housing community, and that's what they got to do. So it didn't interfere with their uses. The character of the ordinance interfered somewhat, but the court looked at it and said, you know, what we're doing here is protecting affordable housing. We're trying to fulfill the goals and purposes of the housing element of our comprehensive plan. And that's a requirement that we have under the Growth Management Act. So by adopting this zoning ordinance, the court said that you're regulating for legitimate public purposes. It's a rational basis to allow somebody to use property only for manufactured housing, and it does not violate the takings clause. And so the Ninth Circuit looked at Tumwater's ordinance, and it has become a model for other cities across Washington. I've had a virtually identical case in the city of Kenmore, where Kenmore adopted this approach to protecting manufactured housing communities. And that case went nowhere in the Growth Management Board, and it went nowhere in the courts. So it has now been dismissed. There are lots of things in addition to the Growth Management Act that underlie our land use laws, and we have to be consistent with all of these different laws. And thank goodness we have Karen to keep us on track. And when Karen gets a little overwhelmed, she may even give me a call. But Washington has laws that require you to go to the Planning Commission, get their recommendations, have citizen involvement, public hearings, and bring those proposed plans and regulations to the council for action. It used to be that we did this under the Planning Enabling Act. Growth management has become even more prescriptive as to how you plan, the subjects that you are required to plan for, and the requirement that you be consistent between the elements of your plan, that your development regulations are consistent with the plan you adopt. And so you have consistency vertically with the plan and consistency amongst the different elements horizontally between the plan. And then those get implemented in reviewing development proposals, and that triggers the Local Project Review Act. This was what we called reg reform back in the 90s, and it was trying to expedite and put people on a predictable clock so that you would have development proposals considered and acted upon in a timely manner. The development community really wanted that because it took too long to walk through the permit process. And then there was a uniform expedited appeal process in the Land Use Petition Act. All of these development proposals and all your development regulations were subject to some of the older laws, like the State Environmental Policy Act, which requires active consideration of environmental values in every government action, unless it is categorically exempt because it's so small that it's not likely to have a significant adverse impact. So when development proposals come through, you have to look at environmental impacts. When you adopt your regulations, you have to look programmatically at whether you're having a probable significant adverse impact. And you may have to do an environmental impact statement to provide full disclosure. If you're in the shorelines, you're subject to special zoning at a statewide level and mandates from the Department of Ecology as to how you can allow development in shorelines areas. The State Subdivision Act provides a framework for how you subdivide and develop new property, and that's increasingly important in plats. And it meshes with the requirements of the Growth Management Act that you provide for density when you subdivide property that is consistent with urban development and consistent with your comprehensive plan. You know, what are the areas that you're dealing with? How do you address critical areas? All of those things get merged when a subdivision is proposed, and the hearing examiner ultimately has to consider all of those things as to whether or not there is an appropriate provision for public services and schools and streets and all the requirements that are necessary to sustain new development. Joan? You're muted.
It's the only place they can mute me is on this. Zoom.
Joan, we all know you can never be completely muted.
Oh, okay, thank you for that. I'm hoping that you're saying that in a good way. I know you are.
Absolutely.
I'm reflecting back on that mobile home park thing. I can still see that man with the vein standing out in his neck at one of our council meetings. The owner of that, and where does it come in? Because it was argued then that it would hurt him financially, and does that come in? What, in other words, what of this can that apply to? Can it apply to a builder doing homes?
That's what the court decision really sustained, is your ability to adopt regulations that do have some financial impact on property owners.
Oh,
And the evidence in that case was that there was perhaps a 15% impact on his property value. But you have to balance that against the community value of providing affordable housing. And that's what the court sustained in that case.
good to know.
I want to talk about a couple other statutes. RCW 8202020 limits your ability and prohibits imposing any tax, fee, or charge on development that is not expressly authorized by the law, or which is or requiring dedications unless they're reasonably necessary as a direct result of the proposed development. That is a lot like the Nolan-Dolan test. And so Washington has used 8202020 to look at whether or not your development conditions are adequate. There were a couple of cases that were decided a few years back that decided that it went too far. In the Citizens Alliance case, King County limited clearing of lots to 50% of the area of the lot. And the court said that that went too far. It was, in essence, an indirect tax, fee, or charge on development. And so it was invalid because it was prohibited by RCW 8202020. Similar holding in the Isla Verde versus City of Camas case. There, the development ordinance required new developers to set aside 30% of the land within the subdivision for open space. And the court said that that was a tax, fee, or charge, and held the city liable to pay for the costs of the value of that 30% set aside to the developer. And so 8202020 is something we always have to be mindful of. In addition, the Benchmark Land Company case versus City of Battleground dealt with frontage improvements that were required on a street that was adjacent to the subdivision. And the facts of this case are really kind of important because the exit from the subdivision went out onto a main road. And the main road was what the city required these frontage improvements on. Well, when you went out on this main road, everybody turned to the right to go to the city. And the city required the frontage improvements to that direction. They also required it to the other direction where there were very few trips shown in the traffic study. And because of that, the court said that you could not require the developer to install these frontage improvements because the number of trips didn't create a safety hazard and didn't trigger the impacts to safety and that justified requiring frontage improvements there. So we almost always see developers challenge the imposition of requirements like this because there's not enough impact to justify those. And they cite the Benchmark case. So what are our responsibilities? How can we make a difference as council members? Brad mentioned, we're in the midst of comp plan updates. Comp plan updates and regular scrutiny of our comprehensive plan via the annual amendment process. Those are two ways in which we have the ability to make a difference, to establish what our vision is and what the community's vision is for what we want our city to look like. That's a policy decision that you get to make as council members collectively. And then you put that together as part of the comp plan, you send it off to the state and make sure that they believe that it's consistent with the Growth Management Act. And then you get to write your development regulations to implement that, your zoning code, making sure that the regulations that protect critical areas are clear and protective. Making sure that the development regulations provide density in the areas that it's appropriate and provide lesser density where it's inappropriate to put too many houses. All of those things are an exercise in writing the rules. Everything goes to the Planning Commission first, and then those rules come to council and you get to make the final decisions. You don't have to follow the Planning Commission's recommendations. You get to decide. I'll tell you, a lot of you probably came up through the Planning Commission. It's a frequent way in which council members get experience in how to work together. The Planning Commission does that. They look at things and they give you their best advice, but it's advisory only, and then you get to make the decisions. But it is somebody else's job to implement those rules and to figure out how they apply to specific proposals. In Tumwater, the ultimate decision maker may be the hearing examiner, who gets to hear appeals when citizens don't like the staff interpretation. Some of the decisions, like plat decisions, go directly to the hearing examiner, who holds an open record hearing, hears the evidence, and makes a decision as to whether to approve it, consistent with the rules that you have written as council members. He's the final decision maker on these open record predetermination hearings, things like plats, things like conditional use permits and variances. So he has sort of dual responsibility. There are numerous ways to and opportunities to influence the outcome of development proposals. But the council's role is more general. It builds at the bottom of this pyramid through the comprehensive plan, writing the zoning and subdivision ordinances, setting what the standards are. And then as you go further up, you have more administrative responsibilities and less discretion. When it gets down to whether or not you get a building permit, you look at and see whether or not the code provides for a building permit to be issued, and it is often referred to as a ministerial permit. Subdivisions, a lot more complicated, a lot more discretion, so that the hearing examiner has to listen to the community testimony. And then he has to see whether or not it fits the rules that you wrote as part of your subdivision ordinances, as part of your zoning ordinances, as part of your development regulations. By the time it gets to project review, it's often too late for the council to have direct impact. You have to plan for that as you write the rules. And one of the ways in which that gets done is to consider annual dockets and annual amendments to the comp plan and amendments to your development regulations that help implement those amendments. So you can have a regular process, but the Growth Management Act limits you to one time a year. And that's why you have that docket of different proposals to consider on an annual basis. What do you do?
Jeff, I have a question just for my knowledge.
Yes.
Um, who is the hearing examiner? Is the hearing examiner a judge or seasoned lawyer in real estate law or planning law?
Yes, the hearing examiner for the city of Tumwater right now is a man named Mark Scheibmeyer. Mark is a very seasoned lawyer. He had a small practice in Chehalis, and he then got into the hearing examiner business about 20 years ago. He was the hearing examiner for the city of Olympia. He does so most of his practice is he's hearing examiner for various jurisdictions. And his entire practice is listening to land use applications and deciding whether they meet the standards that are in the development regulations.
Okay, thank you.
And so there are opportunities to keep paying attention. And if you think that the process isn't working well, there are opportunities to amend the policies in the comprehensive plan annual amendments, or to amend your ordinances by making text amendments to change the rules so that they are more clear and that they work better. One of the ways in which this came up in Tumwater recently was the development guide had some regulations about undergrounding of utilities, and that was challenged by one of the developers, and the hearing examiner agreed with the developer. So one of the things that we recommended was that you make more clear that it is the obligation to underground utilities in conjunction with new development projects, and that staff would have the authority to require that in most situations. So some do's and don'ts. I think when you get complaints from people in the community, and the people are going to come to you as their representatives, what do you do with those complaints? Communication with staff, and that of course goes through the mayor, through the city administration, and refers it to them for resolution. Communication is fine. You should be getting updates from staff as to what's been done in response to those complaints. You should be listening to the public. And you shouldn't be in a position of saying, oh no, I can't listen to you because it might be the appearance of fairness problem. Because you've given the final decision-making authority to the hearing examiner, you don't have to worry about appearance of fairness. You get to listen to the public and respond to their concerns by changing what those laws and regulations might be. Councilmember Agabi.
Thank you very much. Can you go back to you give the example of the a situation whereby the city's intent is that all newer development run utilities underground, and what was the disposition? Was the disposition that the city did not intend for that to happen?
I think that the city did adopt amendments to their development guide that make it clear that development will need to be undergrounding utilities where it's feasible.
So before the clarification, wasn't that the intent? Was that not made clear that they have to do that?
The hearing examiner didn't think it was clear enough in the rules that were adopted at the time they made their development application. And under what's called the vested rights doctrine, that's what governs. So
okay,
going forward in the future, that can be changed. And that's what we recommended happen with the undergrounding of utilities. Because we do think that underground utilities promotes a lot of different community values. Councilmember Dahlhoff.
Thank you.
Thanks. Going off of Peter's question comment, when that situation arises in the future, do we have an opportunity to discuss the impact of that? Say we were looking for another manufactured home development, right? We've been trying to get different types of housing, and then we require to underground, right? But we're trying to do affordable housing. But if that cost then is put on the tenants that are I deemed it affordable. Do you see, like, if there's a contradiction there, we're trying to do affordable housing, but yet we mandate this and they put the cost on the tenant, so it's no longer affordable. Where's the flexibility we have to say where it applies and where it doesn't?
That's part of the policy debate and the things that growth management requires you to look at multiple different values and try to make them fit, try to make them consistent. And the more costs that you impose on a development, the less affordable it may be. And you know, there's affordable tax credits, there's all kinds of programs to try to incentivize developable house or affordable housing. And I think that's a discussion that you as a council have to constantly have as to, if we require X, are we impacting Y? And all of those different things are the values that the comprehensive plan requires you to look at. If we require dedication of more parking, does that impact the protection of trees? If we require open space and tree protection, does that limit the amount of space that's available? And does that have an impact on the availability of commercial development or of housing? All of those things have to be balanced, and that's what the council gets to do.
Thanks, Jeff.
So I think you need to stay informed about all of those community concerns. Look at how it impacts the environment, look at how it impacts these different policy elements, and try to decide what is working, what is not working. Look at other communities and see what is working there, and maybe you can bring it to Tumwater. Councilmember Van Holtz.
Thanks, Jeff. I'm wondering, when the hearing examiner is hearing, do they ever pause? Like, I remember when I was not a council member yet, but, you know, meeting a lot with community members, and there was a development being planned, and people were worried about traffic and all these new homes. So would a hearing examiner ever pause for like a traffic study to be done, or is it just based on the information that they have readily available?
The rules that you have written require developers to provide information that assesses those impacts. SEPA requires that you address whether there's a probable significant adverse impact. And so the hearing examiner is going to look to see, did they provide the information that is necessary? Your staff has responsibility to make a recommendation that is informed, and they can require additional supplemental information as part of the application review process. And yes, the hearing examiner will look to say, do we have adequate information to make this decision? And ultimately he might say, you haven't done your homework. I'm going to send this back for more work. And the hearing examiner has the authority to do that. Couple other things. Don't make promises to the public about projects. You get to write the rules, but other people will be figuring out whether they comply with those rules. And you don't want to be in the position of making promises that you can't keep. There's also liability concerns. If you make a promise that a project will go through, and then the decision is it doesn't meet the standards, the developer might come back and say, you promised me this project would go through. And that's a recipe for litigation and lawyers to get involved. Let the appeal process work out. Let the project review process work out. Let staff identify whether or not the traffic impact analysis is adequate. And just as a reminder, staff is directed through the mayor and through the city administrator, and council don't direct staff how to do their jobs. They're land use professionals. City has hired really good people, and over the 30+ years I've been doing this with the city of Tumwater, I've been incredibly impressed with the quality of staff in your land use department. The land use process doesn't second guess the policy choices, but you can watch how they are implemented and revise as necessary. But remember, that may not affect the proposal that is filed their application and is in the pipeline. Councilmember Althauser, you've joined us.
Yeah, apologies for being tardy. I'm out of state at a conference and I forgot how time zones work. So I thought I was 20 minutes early when in fact I was 40 minutes late. But my sort of question is about our system versus the system in other jurisdictions. Like Lacey seems to have a hearing examiner and a similar sort of binding process, but they also have votes on specific projects towards the end of that process, which I think personally creates a lot of confusion for the public because it seems like there's a thumbs up or thumbs down about specific projects and specific developments when in fact, isn't it the hearing examiner that still has the power in that situation? And is that a accurate sort of interpretation of their system that they have compared to us?
The system that Lacey had adopted, and I believe they moved away from this very recently. The system that they had adopted was one where, and Tumwater used to have this system, where the hearing examiner would make decisions after an open record hearing. So he would hear all the witnesses, he would hear the testimony, he would render a decision. And then his decision could be appealed to council. And council then had a quasi-judicial role in determining whether or not the evidence that was produced to the hearing examiner satisfied the development regulations and was correctly decided. That creates this sort of inherent conflict between your ability to communicate with the public about the development rules and triggers things like the appearance of fairness doctrine and whether or not you have had improper communications with people. And so they decided, and Tumwater decided a long time ago, is to give that to the professional land use attorney, the hearing examiner, and make that directly appealable to court rather than appealable to the council. That way you are a pure policy-making body. And that's, I believe that Lacey has gone to that fairly recently. I know I gave a presentation recommending that a couple of years ago. So they're getting out of that. And part of it was because there was confusion over what some of the requirements were for a particular development. And the concern was council was kind of inventing the conditions on a case-by-case basis. And that creates possible exposure. And it's really one of the liability traps that exists for council, because they were trying to be responsive to the neighbors and what they were hearing from the community about that particular case. And so they were trying to come up with a solution. The law is pretty clear in Washington that community sentiment is not the basis for how you decide land use issues. The basis is the rules that you write and the policies that you've adopted as part of your comprehensive planning process. Now, in Washington, there's all sorts of different ways in which you can be held liable. RCW 6440 makes you liable, makes the city liable if their decisions are arbitrary and capricious or knowingly unlawful or unreasonably delay beyond a statutory deadline. Councilmember Agabi, yes.
Thank you very much. So for the for the examiner, if they have adjudicated a case and that case is appealed to the court, does that then create a de novo trial, in which case the applicant can submit newer information that was never used or considered by the examiner during that process?
No, actually, the review in court is based on the record that's created before the hearing examiner.
So in which case the record is closed then?
The record is closed. There are very rare exceptions to that where you can try to supplement the record, but for the most part, the record is closed.
Thank you.
And Councilmember Dahlhoff.
Yeah, Jeff, I'm just on this slide you're at, like these examples, delay, damage, knowingly unlawful. Would a current example be Cle Elum filing for bankruptcy because of delays in a housing project?
Yes, and we're going to get to Cle Elum and talk a little bit about what went south for Cle Elum in just a minute. But want to talk to you a bit about some of the other liability cases that have. Whoops, let's go back to this one. The Mission Springs case. This was, God, has it been 27 years since Mission Springs? This was one where the hearing examiner had approved a new plat, and the community continued to express concerns to the council members, asking for more traffic studies, asking for more environmental impact analysis, a supplemental EIS. And the council, under their codes, did not have any further role after the hearing examiner had decided it. And the council nevertheless suspended the permits and required additional work. And that created lawsuits because they did so at a meeting in which the city attorney told them that they didn't have the authority to do what they were doing in open session on the record. And that was the first paragraph of the court opinion that talked about the liability case in Mission Springs. The council disregarded their city attorney's advice, and they lacked the administrative authority to intervene in the permit process, and were found liable because they interfered with vested property rights to the development permits. As a result, the court said that they were arbitrary and capricious, were liable for damages, they violated substantive and procedural due process rights, and the members that voted for this were found not to be entitled to legislative immunity because they were acting in an administrative capacity. Therefore, they were personally liable and subject to claims for punitive damages. This was years worth of liability, and multiple millions of dollars ultimately were paid to Mission Springs. Another example you may have heard about in years gone by is the City of Burien case, the Westmark case. This is one where some state legislators may have intervened in the permit process. The City of Burien got an application for a big apartment complex. They dragged their feet. They ran the SEPA process for over 3 years. And then when they thought they had a settlement agreement, they misrepresented that it was approved in an open public meeting. The developers brought claims for intentional interference with business expectancy, negligent misrepresentation, unreasonable delay, and the developers won. The city had delayed this in order to satisfy some of the state legislators who opposed the development. One of them wanted to set aside the area where the development was proposed for a park or an open space, a green belt. The court said that that was improper. The city was liable for interfering with their business expectancies, and the verdict came out to $10.7 million in damages, plus attorney's fees. Total liability was about $14 million to the city. So land use decisions can generate very large dollar values if they go south and get to court. Thurston County found this out in the Maytown case. Maytown had purchased this property from the Port of Tacoma, which owned this property down in the Maytown area, for the express purposes of operating a mine. Their special use permit came up for a 5-year review. The county began demanding additional environmental studies. What it really turned out was that several of the commissioners were more concerned about getting elected and satisfying the Audubon Society, which had some legitimate concerns, but it was too late because they were already operating and already had a permit to operate the mine. The county got sued for interference with a business expectancy. The port was unable to sell to any other company, and the court found that the county's conduct of asking for all these additional studies shocked their conscience and violated their constitutionally protected property rights to due process. $8 million was awarded to the Port of Tacoma, and Maytown Sand and Gravel got $4 million. And so, that is a very large judgment. Many of you may know Commissioner Valenzuela. She's a former city council member on this body. And she was acting in good faith, I think, from her point of view of trying to protect the environment. But instead of doing so through rewriting the rules, they tried to get involved in permit decisions, and that really ended up unfavorably for the county. I want to talk to you a little bit about development agreements, and this leads into where Cle Elum got into problems. Washington law allows you to have development agreements. A development agreement sets the standards for a big development, something that's going to take years and years. And developers don't want to invest what's necessary to run that through the permitting process and through the development process without some assurance that the city is on board and that the rules are not going to be changed halfway through and they're going to invest a lot of money for nothing. So a development agreement sets the development standards that are going to govern for the time period of that development agreement. It may be 10 years, it may be 15 years, but it sets what those are. It gives the developer certainty as to the standards, certainty as to what their impact fees are going to be, and certainty as to what the mitigation requirements are going to be. Typically, you will then see the development proceed in phases. The development agreement then obligates somebody to fund or provide services, infrastructure, or other facilities. So the developer may say, in exchange for bringing this wonderful development, city, why don't you extend the sewer line out here and bear that infrastructure cost so that I don't have to. And it makes it more attractive to the developer to bring this development if the city is on board with that type of investment. The city has to have public hearings and adopt these by ordinances. So that necessarily involves the city council. The development agreement, once it's approved, gets recorded and it's binding on the parties and their successors. So this is one situation where a contract, a development agreement, will bind the future the council, and protects against shifting political winds that the developer might find adverse. Well, this is what happened in Cle Elum. Cle Elum had to file for Chapter 9 bankruptcy to reorganize their debts. They had entered into a development agreement in 2011 for a development known as the Idera subdivision, Idera development. The developer in this case tried to get the city to honor its commitments in the development agreement and felt that the city was not doing so. They went to arbitration as the development agreement provided, and the arbitrator ruled in favor of the developer. I talked to the developer's attorney, who I happen to have a case with right now, and she basically told me that they asked for the moon. And this was a situation where they got it. The arbitrator ruled completely in their favor, and because there was an attorney's fees clause, tacked on an extra $4 million in interest and attorney's fees. So you got $26 million in liability here that the city of Cle Elum just doesn't have the ability to pay right now. So they're going through this bankruptcy process to try to restructure that debt and hopefully stretch it out so that it's more manageable. We'll see if they can potentially reach a settlement with the Idera development, but the court will enforce these development agreements and honor them. And so that's kind of what's happening with Cle Elum. And with that, let's stop sharing and open it up for questions. If anyone has anything that they, Councilmember Agabi.
So your last two examples, the way I understand them, tells me that within the council, there were members that were acting against the vested interests of the common good. So my question then is, how does the council as a body forestall such action from taking place?
Can you ask that one more time?
So my question then is, how does the council forestall members of the body from committing to an action or certain actions that binds the city or council to further liability down the road?
One way is to train people not to take action that is beyond the scope of their authority. The other is, like in the Mission Springs case, to have discussions with your legal counsel and to follow legal counsel's advice, because Karen gives you, pretty good advice as to how not to incur the kind of liability that we saw in the Mission Springs case, and will tell you when. I don't think any of these public officials are motivated by ill will or trying to do something improper. They see one particular value being compromised, and they're trying to do the right thing. But sometimes in trying to do the right thing, you step outside of the procedures that need to be followed. And that's, I think, where the courts have had issues with cities. And so talking to your attorneys is another good way, I think, to try to make sure that you're protecting the city's interests in the long term. Councilmember Kathy, you're still muted.
Or talk. I have a friend who was on a city council in California, and you know, these ideas of having these agreements, these development agreements, was, I don't know if they went through a phase of having trouble with that, but now they are very, very cautious about doing that because of exactly what got Cle Elum in trouble, which is, and I think some of what Councilmember Agave is talking about, we could decide on some agreement here that's going to take 10 years or something. And in 10 years, the rules for the environment, for example, could be totally different, but they get to do it under what was, you know, 5 to 7 years ago or 10 years ago. And so I think that some places have become cautious about those development agreements.
And I think you should be cautious about them. I think it should be reserved for things which are very significant developments. You've got a brewery that's been vacant for a considerable period of time, and at some point, hopefully, there is a proposal to restore that to a beneficial use. I know that's a goal that everybody in Tumwater shares, of trying to not just let it sit idly by and become an attractive nuisance for people who want to rip out the copper wiring. That is the kind of situation where I think a development agreement, because it is so big and has so many moving parts, trying to provide somebody the certainty that they will then come and invest, that's the kind of situation where I think it's appropriate. I don't think that it is something that you should use for typical residential subdivisions or a business park development that doesn't have that kind of significance to the community. I really think that development agreements should be rare and used for really significant things. And I don't know exactly what Cle Elum did to get themselves in trouble.
Yeah.
But it does go to show that they are enforceable, and if you breach an agreement, there can be damages, and that's what got Cle Elum ultimately in trouble.
But it sounds like that they didn't get the right person to arbitrate it all.
It could be.
I'm glad you weren't in on that.
Well, I'm glad I am not working the Cle Elum case. I'd much rather be down here in Tumwater.
That's good. I'm glad you're here.
Right. Any other questions? That's a great presentation. Thank you, Jeff. Because
I appreciate all the great questions. I'm sorry it went a little over time, but I appreciate the interest, and I'm always available if you have legal issues that come up. I love advising Tumwater, and Karen has me on speed dial.
Yes, she does. So, all right. Thank you. That was
Thank
great.
you so
Yeah,
much.
it's even a reminder for people who've been on here for a while. It's definitely a good reminder. So, all right. The next item on the agenda is food systems plan. And hello, how are you?
I'm great. Thank you so much, Mayor Sullivan. I'll introduce our guest speaker, if that's all right.
Okay, sounds good.
Sure. My name is Dana Bowers. I'm an associate planner at City of Tumwater, and I'm glad to introduce you to Rebecca Podasnik. She's been here before and has, maybe not to City Council. I apologize. So Rebecca is going to tell us about the work for the food systems plan. Now, she has been working really diligently to gather information for our community food assessment, which is in your packet. And then we also have, she's been working on the goals and policies. And so it's really the draft goals and policies we want to focus on tonight. And I hope that the community food assessment was really valuable and provided you with some information. And I'll let Rebecca go ahead. And apologize about the big room. We are gonna share a PowerPoint, and so that will limit our capacity to see you. So if we're not seeing hands up and things like that, I apologize. As soon as we're done sharing the PowerPoint, I will turn it back to camera mode and we can see everybody. So give me just a second to share the screen.
I can also assist in if recognizing people too.
That would be great, because I would love it if people have questions or comments as we go to be able to
Okay.
speak up. That would be helpful to me.
And let's see here, or we could possibly have our clerk share. No, I don't think you have the PowerPoint. I apologize. Here we go.
And while Dana works on the technology, there we go. So
Just a second, I think we're not sharing yet.
you sharing?
We don't have it yet.
And I'm just going to start talking because the PowerPoint is very, very simple. The first slide was just giving you an overview of the work that I've done. And so that work, the big push was to engage with subject matter experts. So I worked with people in the community to inform the community food assessment. Will you do the next slide?
Absolutely.
Great. Well, I did a literature review and I engaged with subject matter experts. And that information is all in that community food assessment, the complete list of people that I engaged with. And so I did interviews with 28 people and then also sent out a survey and got 24 responses to that survey. The survey was a very in-depth survey asking people to basically write like narratives. It wasn't just sort of a quick little checkbox. So for the 24 people that engaged with it, we got some detailed responses. Then I created the assessment that's in your packet that gives an overview, try to capture a snapshot of the state of the food system in Tumwater. And because of the nature of a food system, it has tentacles outside of Tumwater. So you may see things in
I have a
the food
question.
assessment. Yes.
Yes, the survey was sent and it was 24 people. Who are these people? Are they nonprofits? Are they members of the community? Tell me more about the survey.
Yeah. And I'll say that the survey was sent to more than 24 people, and it was 24 people that responded. I think we sent it to about, I want to say like 58 people. If you have in the community food assessment on page 20, it lists everyone that engaged with. So yes, I tried to reach a broad swath of people. So it was nonprofits, it's for-profits, government. I talked with people that were local food processors and producers. I talked with people that are engaged in emergency food assistance. I talked with city staff members. So in collecting the people that I engaged with, I tried to make sure I wasn't weighting it too far in any one area and tried to get a broad swath of people. And I did also bring those lists both to the Planning Commission and to the General Government Committee before moving ahead. So I also got their input and made some tweaks based on things that they gave me.
Okay.
Is that helpful?
Yeah, it's helpful, but 24 just seems like an awful small number.
Well, it was 24 people for the survey and then 28 people that I sat down and talked to. And
Okay.
so, and I will just say I had, certain constraints on what I was able to do based on basically the budget that was given to me. So I do agree with you. And I do agree that, this project could definitely be more expansive. And I was trying to do the best I could in the amount of time and the amount of money that I had.
Okay, thanks.
Can I also remind council members to use your raise hand so it's easier to recognize you?
And not to interrupt, but also to say that we can see you in the share screen mode. So that was great.
Yeah. So the community food assessment tried to capture in there opportunities, challenges, current collaborations to capture a picture of what's happening, and then to use that to draft goals and policies and ultimately implementation actions that you all can put forward. The goals that I was given the 3 overarching goals, and you could go to the next screen. So the first goal was providing access to fresh, nutritious, culturally appropriate food for all members of the community. I will say the goal, I think the original one that I was given was just framed how to provide healthy food for all members of the community, but that has been fleshed out a little bit more based on the work that I did. The second goal, I'm just going to read the overarching goals and then we can get into the policies. The second goal was reducing food waste that I was given. And then the third one was supporting local food production and processing. So with those goals in mind, what's before you tonight is those goals a little bit more fleshed out, and then some proposed policies to support those goals. Then the next step would be a series of implementation actions to further get into level of granularity of how to actually make those policies come to life. So I was told tonight that I have a brief amount of time with you, so I'd really like to focus. I'm happy to answer questions. And the part that's really valuable to me is to get your input on these drafts that I'm putting before you so I can adjust them based on your feedback. So this first goal that's before you, which I read the goal, and then you've got those 5 policies. And I will just turn it over to you to hear what you have to say about these policies.
All right, any comments? Councilmember Doha?
We've gone through this a few times in general government, and I really dig this version that we're seeing. So I really appreciate this. I think it's great.
Council Hauser?
Yeah, I was just gonna say the same thing Leetta did. I think we've gotten 2, or is it 3 presentations on this so far at general government. So there's been a lot of work that's sort of gone into the fleshing out of these goals. I think they sort of represent a lot of the conversations we've been having over the past really 2 to 3 years. You know, these things periodically come up, I think. It's a big question we get a lot from constituents, and I think these sort of embody a lot of the community feedback we've received.
Great, thank you. Councilmember Von Holtz?
I'm just wondering, this is all really great. I'm just wondering with what we may be looking at as a state with reductions to SNAP benefits, making food insecurity even more of an issue with our community. Does what you've done provide for anything like that?
I did not, it was beyond the scope of my work to be staying current with all the changes that have been happening with this new administration. So I would say no, I'm not directly addressing that in this plan, although, I mean, even that overarching goal, I feel like does say that, because it says that your intention is to make sure that people have enough to eat. How you go about doing that is going to be a bit of a moving target, because we don't really know. I don't know, and is beyond the scope of my expertise to be able to advise you on that.
And I do want to just take a moment to add a tiny bit of background, because what we want to really put forth is that the goals, the overarching 3 goals that Rebecca read, were the scope of work that she was provided, as she said, but that was the intent of this, to frame it, because it could have been a much larger project. And parts of that much larger project could be done at the request of the council. And then also expanding from this, these are the goals and policies, and the next step is implementation action items. And those implementation action items really are how that is accomplished. And those are very much like our draft implementation actions and the comprehensive plan, those are where the council gets to decide how we're going to budget, how we're going to spend funds. So that's kind of the exciting part, but then it's also the nail biter because that's where the funds come in. And I also wanted to say that, you know, these align, it's intended that this aligns with comprehensive plan, that this would be a 20-year planning horizon, just to make that real clear.
All right, Councilmember Gabi, thank you for that clarification.
Thank you, Mayor. So as I read this right, am I missing something because it doesn't speak to access point? And I say that because I have children in the Tumwater school system, and I noticed that when they come home, among the several people that they bring home is well, if you need XYZ, talk to XYZ. So do you kind of work with the school system to access, or am I just too far down the way?
I did speak with, I had subject matter experts from the school district that did inform this. And so there is information there about the school district. The other thing that I would say is I really focus this on what is within the city of Tumwater, what can the city of Tumwater do? And there's definitely, it was very educational for me when I was sitting down and speaking with the director of the food services for the school district of Tumwater about where they get their funding from, how that works. And it seems like very much a division there between the city and the school district. Some of the implementation actions that I heard from subject matter experts, there are places where I feel like y'all can partner together, but there's certainly things that you have little control over about meals in schools.
Yeah, we're two different entities.
I'm being really conscious of the time, so we'll move on to the second goal, which is reducing food waste. These were the 3 policies that I'm proposing to support the goal of reducing food waste. And much like the issue with the school district, some things about how waste is handled is not just the city or things with partnering with the county.
Councilmember Kathy?
Thank you. Thank you, Mayor. I was just wondering, did you talk to anybody from the solid waste system at Thurston County? Thurston County?
Yes, I did. Yes, I did.
There's been a lot of work done on this over the past couple of years through the county and through our you know, food systems as far as food waste and you know, and also there's a new outreach program there that goes into schools, and so there's some collaboration things possible through that through the county program. So I'm encouraged by that, and I can talk more to people in the city about it. And it has to do with just some of the things that you're talking about, food waste and, you know, composting and small gardens and all kinds of things. So
Thank you.
good. I'm glad you talked with them.
Yes. If there's no other questions or comments, we'll move to goal 3, which is supporting local food processing and production. Here are the 5 policies that I'm proposing to support that goal. And again, welcoming your comments, questions, and feedback.
Councilmember Dolpha?
Thanks, Mayor. In one of our past meetings, we talked about just the concept of little free pantries, right? Like we have one in the manufactured home parks, we have one in a Mountain View Church, there's one over by JJ's. Just to verify, that could be included in this, right? It's broad enough that that's an opportunity to discuss moving forward.
And the way I've captured the work of Little Free Pantries is in goal 1. So I'm not seeing for local food processing and production, I'm really talking about those people that grow our food or do other processing of the food. The goal number 1, which is
access
providing
piece.
access,
Got
is
it.
really where things about free pantry and free food distribution shows up. But yes, it's
And-
definitely captured.
Thank you. And really, these aren't siloed, right? They overlap. So if there's excess production, excess, right? They all tie into each other.
Absolutely, yes.
Thank you. Great work. Thank you.
Mhm.
Great. Any other questions?
And if you put the last slide has my contact information. And so if something does come to you or you dive back in and spend more time with that community food assessment and you've got comments, questions, please reach out to me and I will get back to you. And actually, Deanna, great.
And I also wanted to say in your packet, we have a little timeline at the end of the staff report. And there has been an update to it since we wanted to give a little bit more space for the subject matter experts to review and give more input to the implementation actions. Then we're going to shift the timeline. And so your next meeting in September is going to just really focus on maybe legal and SEPA review of those action items. And then we'll have another work session October 14th with the City Council, and you'll see those action items, and then we'll bring it back November 3rd so that you can decide on it.
Great, thank you. Councilmember
If it's your will.
Councilmember,
Yes, I just wanted to give you a heartfelt thank you. There's an urgency to this to me, especially now with our environment. You're doing important work and our community is going to need this. So thank you very much.
And Councilmember Jefferson, I will say that when I've been talking to doing those interviews and surveys, I repeatedly got feedback that really lauded the city of Tumwater for doing this work. So your community appreciates that you're putting attention on this as well.
All right, and we're leading by example. So hopefully our neighboring cities can see the good work that you ladies are doing. Thank you.
thank you. Councilmember Swarthout.
Thank you, Mayor. I realize that they will not be able to answer this question. I guess this goes back to the land use. I think some of this came up because of the food distribution that was happening up on off of North Street. So I was just curious, does this help resolve some of this? Are we closer? Or what, do we have any information update on that? Where that's headed? Is this report part of this?
And she's talking about the folks on
Yeah.
Hoadley Loop.
Yeah.
So I will say I reached out to the folks there at Hoadley Loop and invited them to participate and sit down and participate either for an interview or a survey, and spoke with them and gave them some written information. They never followed up with me. I did spend time, I went on a distribution day and the board president was there and he spoke with me at length and I asked for him to follow up so we could sit down, and that didn't happen. And then I've also tried to do some research to see if there's model ordinances in other communities across the country, because there are people that, you know, are studying food system work, to see if there was anything that I could share with you. And I haven't been able to come up with examples from other communities that have some policies in place.
Well, because they do talk about, like, even in cities having food deserts. So I'm just curious, yeah, that where we could potentially have food deserts. So thank you. And I see city administrator, sorry.
Yeah,
Yes, I just wanted to address that from the sort of the where we are at administratively with that issue. The issue is not resolved at this point. The challenge with the Hoadleys is, with the Hoadley property, is that it is not consistent with what's allowed by the zoning code. And so this policy work that's being done is going to establish the context within which the council then can come in and address zoning text amendments to see how and if and when and where you might allow that type of activity to occur. So this is really setting this is the policy level work that Jeff was referring to. And then the next step is to take a look at the zoning regulations themselves to make changes that would consider allowing this type of activity that the Hoadley Street properties are conducting to occur. The challenge that he addresses and the challenge with that work is that it's very good work that they're doing. And it is also impactful to their neighbors in a single family residential zone. And so
Right.
those are the policy level challenges that the council gets to discuss. And this policy work that Rebecca is doing very much clearly establishes the importance of food security and it establishes the policy basis by which the council can then say, this is what we need to do in our zoning text amendment in order to address and implement our policies in our food system plan.
Perfect. Thank you.
Councilmember Kathy?
Thank you, Mayor. I want us to think about this also, that things are different than when we first started talking about this and ended up deciding to do this study, and all of what went on for a while there, questioning what was going on and so forth. We are in much more desperate times now than we were then, than just a year ago. And we're headed into some years that are going to still be difficult. And I think one of our conversations and how we need to look at this situation is we have to balance an incredible need in our community. And for us to go by what we say we believe in and what we do, and people come first, and all of the things that Tumwater has written down and done in the past, we're talking about a critical thing. This food insecurity and medical insecurity and just the whole gamut of this. I want us to be really, really thoughtful about this, and to understand that people want to take care of their people. So we're probably going to see more of this like come about in churches, or we're going to see it come about in a community of women that started out as a book group and now they decided to do something. I just think that organically there are going to be more things that happen. And I just wanted to say that as a thing that's going to challenge us, but also how do we meet that challenge, and how do we make rules, and how do we do that kind of thing? So anyway, I just think this is for me, it's different than the first go around of when we started talking about how we're going to help feed our city. We're down the road in some emergency territory here. And the other thing I wonder, just quickly throw it out, we don't need to answer it, but have we talked at all about how any of this could be shared regionally? I mean, what is Olympia doing? What's Lacey doing? What's going on in our region with some of these same questions?
I will say that is something that came up in talking with people, and there is information in that community food assessment. One of the very first pages in there is I give an overview of some of the history of regional collaboration that's happened. And I would say there is one of the policies in there is specifically recommended policy to really put attention on regional collaboration. I think it's particularly important when you're talking about the food system.
Yeah. Thank you for that.
Councilmember Althauser.
Thanks, Mayor. This isn't a question. I guess this is just a comment. I just think it's worth noting that this is coming at a really important time, just given all the changes that we're seeing at the federal level to food benefits specifically. like the maximum SNAP allotment will be reduced within the coming year. A huge swath of Washingtonian families are going to be kicked off of SNAP as a result of that too. And it's just going to put more and more and more strain on the systems we have that are already underfunded, like food banks, that we don't have a food bank in Tumwater. There's one in Lacey, there's one in Olympia. So I think it's just worth noting in terms of context for the greater system is that the strain was already not meeting demand, and now demand is going to be even higher than it was before. So I'm just glad that we're taking this step now and kind of working on this because it's quite timely.
And I might add, or just the food bank distribution center is in Tumwater though, but we just don't have it.
Right, but consumers don't go there. That's
Yeah.
the distribution.
Yeah. But you can go volunteer and help in Tumwater. All right, any other questions? All right, thank you. We will be getting much more of this. I really appreciate all this hard work. And I think it'll be very, very beneficial. And like all of us, the future is unknown. At least this will give us some idea of where we're at the moment and be able to make adjustments and understand what resources are available and what we need to focus on. So I think this will give us a lot of tools, and hopefully our neighboring communities will also find this useful. So thank you. Thank you. All right, next item is the Olympia Lacey Thurston County Tumwater Fan Zone 2026. And I will turn it over to Administrator Parks.
Great, thank you, Mayor. Just give me one quick moment here to share my screen and start the presentation. Okay, are you seeing the presentation mode?
Yes.
And not my notes?
That is correct.
Okay. So this is a briefing for you about a proposal that's being considered by the cities of Olympia, Lacey, and Tumwater, as well as Thurston County. I'm going to go over a little bit about what this fan zone thing is, what the ask is to Tumwater, as well as the other jurisdictions, what the potential benefits and impacts might be, and then just to leave you with some discussion topics. It's not necessary at this point specifically to make a decision, but there is some urgency in understanding if the council is willing to consider a yes position on the request that's being made. So every 4 years, there is an international soccer tournament that occurs. It's called the FIFA World Cup. It is in 2026, the tournament is being co-hosted by the US, Canada, and Mexico. And within the United States, Seattle is one of the 11 host cities that will be sponsoring some of these matches. In more recent FIFA World Cups, there have typically been a series of what they have called fan zones that are set up around the actual stadiums where the matches are occurring. And this allows people to gather and watch the matches together. It's typically a large screen venue, and you're able to watch all these World Cup matches. There's typically food and beverage vendors, and then entertainment and cultural activities happening. It's a big festival essentially during these events. The Seattle Organizing Committee has designated 9 fan zones across Washington State, and those include what's called the Olympia Lacey Thurston County fan zone. So the map that you see is a map of where the fan zones are located across Washington State. And we also have put the source link so you can go and visit that link if you're interested in other information about the fan zones themselves. So at the Olympia Lacey Thurston County fan zone, some of the specifics that we're talking about here, in terms of logistics, the majority of these events are planned to occur on the Port Peninsula in Olympia. The idea is that there would be the live match broadcast would be sort of the featured event, but that there would also be food and beverage vendors, as well as what are described as cultural showcases and community programming activities and sponsorship activities, as well as family-friendly entertainment. I think there's a lot of details still that remain, but those are the basic components of these events. There is expected to be approximately 2,500 people at each of these events. That is an estimate. And then in terms of the dates, so the events are going to be occurring essentially on the dates that there are matches scheduled in the Seattle Stadium. So the dates you see up here, the first 6 dates are the definitive dates that this fan zone would exist. There are potential additional dates, and these are basically more towards the end of the tournament, where they are the semifinal matches, the matches between, you know, for third place, as well as then the final, which would be on July 19th in 2026. Those matches, the potential additional dates, those are not occurring in Seattle. They're occurring in some of the other cities in the 3 country region. But those are possibly dates where this fan zone could be set up additionally. So essentially the request of the jurisdictions, there's a request of the 4 jurisdictions that including the 3 cities in Thurston County for in-kind resources. And those in-kind resources cover primarily staff time. And that staff time would be on different planning committees, such as communications, transportation, emergency services. So in essence, planning in advance of the actual events. It could include staff time at the providing logistics support. So making sure that traffic control is happening, making sure that there are adequate services and facilities there. And then specifically that would include both emergency services as well as security. The amount of in-kind staff support from each jurisdiction might vary, and at this point in time is not specifically understood or defined. That would be developed, I believe more information would be developed through these various planning committees. There also is in-kind support in terms of facilities. They are anticipating a need for parking areas, so it could be that there are parking areas or facilities in the city of Tumwater that would be necessary for shuttle services to and from the event, perhaps. It could be that there is equipment that's needed to assist with the day of the event. And then there is a request within the in-kind resources for assistance with marketing and promotions associated with the event. As I mentioned, the participating jurisdictions specifically are Thurston County and the 3 cities. The Port of Olympia is also providing in-kind support, particularly in regard to the location and all of the work that would go into actually planning for and setting up for the actual events. Councilmember Von Holtz?
I'm just wondering, because it says Olympia, Lacey, Thurston County. Whereas if it's the 3 cities, why is Tumwater not named?
I can't answer that question. The process of becoming designated by the Seattle Coordinating Committee as a fan zone was conducted by others, and I don't know how or why it did not include Tumwater in the title.
So when the meetings happened up in Seattle, was Tumwater not at those meetings? Is that maybe what the issue might be?
That could be. I don't know who participated in those meetings up in Seattle. So then the other ask of the 4 jurisdictions is for $375,000. Yes, Councilmember Jefferson.
Yes, I believe this is an Experience Olympia and beyond, because they've been discussing this fan zone, but now it's just coming to fruition. So perhaps like how it was named Experience Olympia and Beyond, and Tumwater wasn't involved in that name. I'm thinking perhaps that's what this is all about. So my guess would be that, but we can ask Experience Olympia and Beyond.
I could follow up and try to find the history behind the naming of the event.
Yeah.
It was there have been a lot of conversations beginning actually late last fall about this opportunity. It is a tremendous opportunity for the state of Washington for sure. And there have been lots of conversations. The Seattle Coordinating Committee is the one who determined where these fan zones would occur. And I believe they did some proactive outreach to places, to local governments specifically. And then potentially they also were reaching out to other entities such as Experience and Olympia and Beyond. But I don't know if that's the case specifically. So in terms of, so then there is a cash contribution being requested of the 4 jurisdictions, the 3 cities and Thurston County. Councilmember Swarthout.
And with that, since we're not included in the title, but we're expected to pay full share. I'm wondering if there's, with VCB, we don't pay the full to belong to VCB, we don't. So I'm wondering if there's any wiggle room on that expectation, because and also being, I don't mean to be a jerk, but being chair of the LTAC too, that we've have events that happen at the port over the summertime, and we have supported them through our LTAC funds, but we see very little or minimal return to Tumwater. So I'm just really wanting to have some questions about the benefit that we'll see, heads and beds and stuff like that for Tumwater. So
Yes, and that is coming. And at this point, the request is for all 4 jurisdictions to contribute $375,000 each, and to do so in quarterly payments, beginning in the 3rd quarter of this year and ending in the 2nd quarter of 2026. This is a jurisdictional conversation that has occurred, and the designation has occurred, and the jurisdictions, because of some legal requirements for obtaining sort of the how-to book to accomplish these fan zones, the jurisdictions have asked the Thurston County Chamber to actually be the logistics organizer and the entity that's taking on the process for accomplishing these events. So in this case, all of the materials that I presented to you in your packet are actually are coming from the person that the chamber has hired to assist with following through with what was asked of them, which was help us organize and pull off these various events.
I just might add quickly, I have made my comments about sharing equally in the cost and our name not being included. I have made mention of that on a couple of occasions. So it's not that they haven't heard it, they just haven't responded to it quite yet. Councilmember Kathy?
Where does this amount of money come out of our budget? Where this is?
I have information about that. I have options for you. This is a question to the council. This is you are being asked whether or not the city of Tumwater is willing to participate. So I'm going to cover the request, and then I will provide you some information about potential impacts and implications that your management team has thought of. And then I have also identified, if you were to choose to move forward, where potentially the money could come from. So I hope to get to that, council member, sometime soon.
Okay, at some level here already, the discussion has been had that how this would be advantageous to us or to, I'm just wondering what, I'm just wondering what, so continue, I'll probably get my questions answered.
Okay. I'm not sure who was first, Councilmember Agabi, Althauser?
Yes, it was Councilmember Gabi.
Thank you, City Manager Lisa. So, for some of us that come from the football playing world, when I say football, I actually mean the actual football you kick with your leg or your foot. That's a religion. And every 4 years, we have what we call the football extravaganza. It's a jamboree. So, with what has been happening nationally, I don't suppose that any critical thinking person we think that we will have as much of a jamboree as it used to be every 4 years in America, where we have ICE going from city to city, taking people off the street. So I just don't see it. Maybe I'm naive, but we shall see. So carry on.
Thank you. Councilmember Althauser?
Really quick, just to understand as a baseline, and then I really want to hear the rest of your presentation, sorry. Who is asking us? Is it FIFA? Is it the chamber? Is it our neighboring jurisdictions? Like, who is asking us to be part of it? So we weren't asked before, now we're being asked. So like, who is doing the asking to ask us to help out?
Yes, so I'm going to do my best to answer that. And I'm also going to say that I'm also probably need to do a little bit more research. I believe the original request and opportunity to participate as a fan zone came from the Seattle Coordinating Committee, the FIFA Seattle Coordinating Committee. That's the committee that is organizing all of the events that are happening in the Seattle area. That request, I believe, came sometime in 2024, and it came generally to a large group of, it was probably sent to elected officials across the state. At some point in time, late last year, last fall, there were conversations that occurred a couple of different times at what's called the Three Cities Thurston County meeting, which you, I believe, are all familiar with, where every other month, the mayor pro tem, the manager administrator from each of the three cities, as well as Thurston County, get together and talk broadly about regional things. And this request from the Seattle Coordinating Committee has been discussed at that level. There were a couple of entities, I think primarily Thurston County and perhaps the city of Lacey, that pursued it more proactively, generally on behalf of the local governments that meet at the three cities to pursue sort of the opportunity without necessarily knowing all of these details. These details about in-kind implications and cost sharing are very, very recent. They were just discussed at the last Three Cities meeting, largely because through a series of events and instances, the jurisdictions collectively asked the chamber to take a lead. So the chamber has only been involved for probably the last 4 to 6 weeks, maybe a couple of months officially, in terms of being the recipient of the information, the playbook, so to speak, from the Seattle Coordinating Committee on how to do these FIFA fan zones. And so the original request was collectively from the three cities and Thurston County to say, we're interested. There was a designation made in January of this year that we would indeed be a fan zone. And since that point in time, a lot has happened in terms of trying to get information about what it actually meant if we were to be designated this FIFA fan zone. So I'm not sure if that answered your questions, but I'm certainly happy to do a little bit more research on how we got from here, from there to here.
Okay, thanks.
And I might just add, it seems like we had to give this commitment without having details before we could get the details in the playbook. So it's been a very convoluted process and very frustrating. So I would say it's not easy to define.
Right. So this is essentially the request of the various jurisdictions, and all of this, the information on the slide is all taken from the information that is in your packet, which was provided by the chamber. So potential benefits to Tumwater. This is also taken from the materials that you were provided. The idea, the thought process from the get-go, it has been that having these fan zones would help boost regional tourism, might help support local businesses, particularly those in the hospitality industry, and it could potentially elevate Thurston County's visibility as a place to visit and a place to come to. So without having any detailed numbers, there are not any specific estimates, but there are anticipated an increase in hotel occupancy during these 6 to 12 events, 6 to 10 events. There is anticipated to be additional revenue and activity at restaurants and service providers and retailers. And there is some thought that there would be a regional branding and visitor draw opportunity realized from this effort. Some of the benefits that would be specifically realized by businesses, I think the idea is that in part of the marketing and promotional process, that there would be toolkits and signage that could be provided to various businesses that could benefit from people visiting to attend. There could be workshops provided by the chamber that would help businesses prepare for the potential opportunity that this represents. And then again, there would be this regional marketing campaign that would be coordinated and developed and then implemented by all of the participating jurisdictions. So in terms of the potential impacts and implications, there are basically, obviously, two very distinct categories of impacts. There are financial impacts, and then there are staffing impacts. So this is not a budgeted expense. So if the council were to choose to participate in this manner with cash, we would require a budget amendment. I have my next slide is going to talk about the potential sources of where that money could come from, but generally speaking, it would be either from the general fund or potentially from lodging tax funds. It is not inconsistent with this proposal is likely very consistent with the purpose and the stated parameters of the state law that governs our collection and distribution of lodging tax funds. So I will talk about that, more details about those here in just a moment. In terms of staffing impacts, because we're still very early in the planning stages, it's really difficult to know precisely what the level of commitment would be for in-kind support for Tumwater, specifically for staffing impacts. Generally, we can say again that they are looking for people to serve on committees to help plan for this event and to prepare for these events. And then as these events are occurring, it is entirely possible that there could be a request for our law enforcement and or fire and emergency services personnel to be staged and participating in the actual event. Indirectly, there could also be, even if we weren't specifically asked to attend the event, there definitely could be indirect impacts on our staffing resources, primarily through mutual aid agreements. Fire and EMS has a specific mutual aid agreement where if staffing resources in Olympia are being devoted to these events and there are calls occurring in their jurisdiction, we potentially would provide coverage for that. We are happy to do that. We do that on a regular basis. Sometimes the challenge, however, with us, the timing of this, summer is the time when we have a lot of challenges in terms of our own resources. Typically, we have the highest leverage, highest use of leave occurring specifically in the fire department. You know, they schedule their leave at the end of January or at the end of 2024 for all of 2025. So firefighters are signing up for their annual leave a year in advance to ensure that we have enough personnel to cover our minimum staffing requirements, for example. So finding extra people to staff events, whether indirectly through mutual aid requirements or directly to participate the day of the event, is going to be a challenge in the summertime, because we're already stretched thin in terms of managing our minimum staffing levels. The other indirect impact is if our city staff are participating in the planning committees or potentially providing a day of support, we also have city events happening within the same general time frame. It's a busy time frame for our staff who are busy working on preparing for and pulling off city events. So there are a number of impacts and implications. And again, I would say they are largely unknown with any level of specificity in terms of the in-kind impacts. Councilmember Von Holtz?
I'm just kind of thinking, I remember when the US Open came to Pierce County, and it wasn't all on Pierce County to come up with the staffing. People from around the region all volunteered. My husband and I both worked it because it was a cool thing. So I'm also wondering, I'm thinking of in emergency situations like OSO, where all different firefighter departments and police departments all showed up. There's not going to be a fan zone in every county in Washington. So would that be an opportunity? Have you guys thought about bringing in other jurisdictions to help, since we do have our own things to deal with and our own events during the summer?
I don't know precisely if that's been considered, council member. There are, in the budget that was provided to you in the packet, I believe there are a couple of different line items, for example, for public health and safety, EMS services, and I think security services. And I would have to ask the chamber whether or not that was other jurisdictional support, or if that was like a private company that they would intend to hire. I don't have that detail. I think there's always an opportunity to pull resources from other jurisdictions. In and around Thurston County, there are several other fan zones already occurring. So, and they're all occurring on the same days. So
Sure.
the same, yeah.
Sure. I mean, I don't know. I know that there are a lot of people who are excited. I mean, the last World Cup, I think, was watched by, the final match was watched by 1.5 billion people. Like, it is an opportunity for our state. Also, with that comes extra work. And we've seen other events not at this magnitude, but like, I'm just saying it'd be interesting to hear from Pierce County how they handled the US Open, the visitors that come, the extra staff, and it was all pretty much volunteer. A lot of it was volunteer, manning events. I worked in the gift shop, and like, just everybody kind of came together. So I'm just wondering if there's opportunities for that, because I'm sure I watch the other football, Peter, but I know that there's a lot of excitement for the World Cup coming.
Yeah. Yeah, there is. I know that they are thinking of volunteers to provide support. Council member, there is because they've got a line item for coordinating volunteers, and they have a line item in the, or a bullet point in the in-kind where they would ask the cities, for example, to encourage their employees to volunteer. So I believe that they are very much counting on volunteers to help with these events to the degree that they are able to and capable of doing that. So in terms of the fund information, then, as I said, so if money were to be taken out of the general fund, so our general fund budget that was adopted for 2025-2026 biennium, estimated using almost $5.6 million from our beginning fund balance to cover the budgeted expenses. So in other words, the amount of revenue that we were projecting to collect in our general fund for 2025 to 2026 versus the amount of expenses we were projecting and budgeting for required that we would have almost $5.6 million coming from the balance that we currently have in the bank, so from our savings account. So this additional $375,000, if we were to take it from general fund, would basically add in the budget amendment process, would require that total amount that we were pulling from our beginning fund balance would be raised to just under $6 million instead of the 5.6. LTAC funds. So by resolution, we collect LTAC funds. LTAC is basically a lodging tax. We collect 4%. Basically, it's on room stays that happen in hotel rooms in the city of Tumwater. We have average annual revenue. Sorry, there's an extra bullet point there. So let me skip the average annual revenue second bullet and just talk about the current fund balance in the LTAC fund at the end of 2024 was just under $1 million. In 2025 and 2026, we have two budgeted items, or two budget amounts for each of those years. $238,000 in 2025 is budgeted out of the tourism promotion 2%. So that number, the reason it looks the way it is because there was a process last fall, and there was $238,000 that was allocated to specific events that had applied for these LTAC funds, the 2% that goes to tourism promotion. In 2026, we have simply an estimate of the funds that would be available to the LTAC committee to distribute for tourism promotion. And right now, that estimate is $193,000. The other balance, the other 2% is used for funding primarily our historic facilities. So this is money that we use to try and help improve and maintain the two historic houses that we own, as well as the Brew Tower. And so there are projects that are identified in both 2025 as well as 2026 that make up the totals that you see here on the slide. Councilmember Althauser, did you have a question? You're muted.
There we go. Thanks. For the tourism promotion, are those typically annual recurring people? Is it the same events every year? Like, I'm trying to get a sense of if those organizations are dependent upon equivalent amounts being applied for and received, or if the 193,000 could be repurposed for 1 year, and if that would, like, what would be sort of the impact of that on those orgs?
Yeah, I think Councilmember Swarthout can answer that more directly and in more detail than I can, but I do believe that there is a pretty consistent group of people that request the LTAC funds.
The air show, our fireworks, the senior games, there's just a kick in the grass. There's just very, very much Tumwater people that really do depend on the funds that we provide for them. So, yeah.
And there is a fund balance. So if you take the 925,000 and subtract the other numbers, there is a bit of a fund balance, but it's not a lot. And because so you'd have to add the projected annual collections for 25, 26 to the 925,000. So there is a balance available, but there are also a lot of needs, particularly when it comes to the brew tower, the old brew tower that we own, as well as the 2 historic homes. There are some deferred maintenance projects that have not been funded because we're trying to conserve as much as we can out of that 2% for the historic facilities and programming to try and have meaningful maintenance and facility update projects at those facilities. So I did want to put the average annual collections up here. So you see the varying numbers. Both the general fund in the form of sales tax receipts as well as the LTAC funds are dependent upon commerce. So it's dependent upon sales. So as people travel and stay in hotels more frequently, the annual collections increase. As they choose not to travel for a variety of reasons, then those funds decrease. So there's a direct correlation there. So for example, in 2019, we had $364,000 in receipts from the LTAC tax. But the following year, we had almost more than $100,000 less in 2020. And we all kind of understand why that is. There's been a steady increase. 2024 was down from 2023, and I believe our projections for 2025, 2026 are a bit more conservative in terms of the amount of money we are expecting to collect. So I would guess that if you took 193,000 and times it by 2, that's probably what we are expecting to collect in 2026, for example, because there is a correlation there. Yes, Councilmember Althauser?
Do we legally have the authority to levy LTAC percentages higher? Like if we did a 1 year 2%, that would account for most of the 300. That would account for a pretty decent chunk. It'd be increasing the revenue by 50%. That would be like almost half of $375,000 if we expect greater revenue next year.
I think it's by statute.
Its statute limits it to 4%.
Councilmember Swarthout probably knows better than I would need to ask Karen, or we need to do a little bit of research, but I believe we have maxed our ability to collect that tax.
Okay.
And because by statute, LTAC funds have to be distributed based on an identified process by the LTAC committee. If it was decided that the LTAC funds would be the funds that the city would like to use, it would have to be reviewed and approved and recommended first by the LTAC committee as a part of their process. Councilmember Aghavi?
Thank you, Lisa. So as I sit here and listen to how we're trying to come up with this money, I'm reminded again to go back to the point I tried to make before. You know, there's a reason why there haven't been a World Cup played in Hungary, Tel Aviv, or Tehran. That is because those 3 countries would not have the number of fans go in there, and FIFA would not have an event over there. So now America has changed from from 2014 when this issue first came up. I seriously doubt that this football event in America is going to draw on the average 1 million fans. FIFA World Cup average fan is 3 million, and I could go back all the way to the one that was shared between Japan and Korea. So I'm going 14, 15, 16 years ago. I don't know. So the football playing world is outside of North America. I doubt even if the Canadians will even come en masse to this event. Now, if you cannot draw from the Canadians, how are you going to draw from Central America, knowing that they will need a visa to come here? they're not going to get a visa. And we're not going to have 320 million of us in America being fans that go to the zone. That we don't play soccer in the greater number in America. So it's kind of like me trying to sell you a piece of cloth that you have no need for. So I don't know if I'm making my point clear, but I don't see us spending $375,000 just for a fan zone that nobody's going to come to. At best, we might have 50 or 100. That is not enough revenue for us to spend that kind of money. So that's all I'm saying.
Yeah. It's a difficult question. And it is, I am a football fan as well, Councilmember Agave. But I watch MLS football. I don't watch international football. But so I want to say that, you know, if the council determines that this investment is in the city's best interest, the management team is prepared to carry out the charge with, you know, professionalism and commitment. And it is a very unique, one-of-a-kind opportunity. And with our financial and staffing resources already stretched pretty thin in the city budget, it feels like this is a really heavy lift for the city of Tumwater. Councilmember Dolhoff.
Thanks, Administrator Perks. Before anyone gives a thumbs up or thumbs down right now, I feel there's a lot more questions, right? Even Lisa has questions. I would love to hear from Jenny Foglia-Jones, who's taking the lead on this with Thurston County Chamber, to collect all these questions we have. I know Jenny has a ton more information of when Seattle reached out to the highest density populations. That's why Tumwater was not included. I've also heard that if Tumwater does contribute, the title will be changed. I've heard that Lewis County plans to come up and go through Tumwater. I heard that Seattle FIFA is working on an app that could identify Tumwater, right, for places to go. So there's a ton of stuff that's still developing, and I would love to have a presentation or invite Jenny and the chamber before we say yes or no right now, because this could be an amazing opportunity. And I also want us to be realistic of that impact. So I'd like to hear some more deets. Thanks, Lisa.
Yeah. Councilmember Althauser.
I think at the beginning of the presentation, you sort of alluded to a timeline by which folks are hoping to have an affirmative response from this body. Can you talk a little bit about what the expectations have been conveyed so that we understand? I think Leetta has a great suggestion, so long as we have time to accommodate that.
Yes, I am not, there is not a specific date certain. There is also, however, a sense of urgency and a belief that we are a bit late in getting started with all of the logistics and the planning that needs to occur in order to pull these events off in less than a year. So I know that, for example, the city of Lacey is having a work session tonight on this topic as well. I believe the city of Olympia is having a discussion of this at the council level. I'm not aware of the county commission's discussion. I think there is likely time if we can get something soon, because we also have a recess coming up in the next couple of weeks. And so trying to get something in where there could be a definitive commitment from the city of Tumwater, you know, it's likely by the end of August at this point anyway, because our decision-making timeframe, we've got recess and other things that are impacting our timeline. So I'm not able to answer that question any more thoroughly, council member. I apologize. I understand that there are lots of questions to be answered. I think there is a lot of work to be done in order to be able to answer those questions. I'm not aware of all of the information that Councilmember Dolhoff is privy to, but I'm happy to ask for the chamber and Jenny to come and do a presentation. I think they are working on this every day. I'm sure that Jenny's doing a lot of research and a lot more refinement of budgets and And that's going to be ongoing for until these events happen. So I'm happy to make those arrangements if the council would like to do that. But I do believe there is a sense of urgency in understanding if there is any appetite on the part of the city of Tumwater to follow through with this investment.
And one more question, have you received any sense of if we were to not participate, would that mean that Olympia, Lacey, Thurston County as a whole for hosting this would be put into jeopardy?
I am not aware of that. I don't know that there have been any backup plans at this point. I don't know. I don't know the answer to that question. I do. Right. I think that's why the discussion happened at the Three Cities meeting, and the reason we all agreed to go back to our councils and have the conversation to try and get an understanding, because the chamber is doing this at the request of the jurisdictions. They're expending resources, and I think they're wanting to understand if that is that expense is going to be covered.
Yeah.
Councilmember.
Okay. Thank you.
Yes. Councilmember Jefferson?
Yes. I believe in teamwork. I believe in collaboration, regionalization, but I'm hearing deferred maintenance projects. I'm hearing sales are going down because inflation. We heard that a report from Troy about inflation and taxes. We are a smaller jurisdiction. Our budget is much smaller. I agree with using city-owned lots for parking, law enforcement support where needed, because we might pay overtime. So that's also, we're paying that. That's the monetary amount that we're going to pay. But I don't agree with the cost share because it should be proportionate. Lacey's budget is much bigger than ours. We know, so is Olympia. So if I was to make a decision, I would say no, but however, when it comes to law enforcement and support, event, banner display on our city property, I'm with that. But if I was to make a decision right now, I would vote no, because it's not proportionate.
So thank you, council member. That basically helps with this current slide. So this conversation has occurred as described throughout the county and in these different groups, primarily in terms of our participation in the Three Cities Thurston County meeting. I also forwarded the materials to the management team and collected their thoughts. And that's where we came up with the impacts and implications slide, thoughts and processes. These are the thoughts. These are the issues that come up when we talk about this. The equitable cost share that Councilmember Jefferson just talked about, the available funds. We already are planning to spend more than we're going to collect, and we are doing so on a status quo type of a budget that that is intended to get us to the point where we are making strategic decisions about what we can and can't afford to fund. There's questions about the impacts for Tumwater. Are they equal? Will people be staying in Tumwater hotels or eating at Tumwater restaurants? There's again, acknowledging that there's a lack of information, not because for a lack of trying, but just because we are where we are in the process and understanding what information is available. And the work that we did at our strategic planning session on Saturday the 28th talked a lot about how do we decide whether or not this expenditure is more beneficial than the use of these resources on some other activity. How do you decide if this is a good use of public funds that is going to benefit the city of Tumwater more so than for, spending $375,000 on other opportunities directly in the city of Tumwater. So this is the work. These are the discussion topics. And I'm happy to try and answer any other questions there might be. Councilmember Althauser?
Thanks. Since we're moving to discussion, I think sort of similar to Lieta, I still have a lot of questions. I'd be interested in hearing more from the chamber if they could be at our next work session, or if that has to be a council meeting, whatever works with the timeline, since it sounds like timeline could afford that. The thing that I think I probably am pretty categorically firm on is that it just seems untenable to add to the general fund deficit that we're already going to have to grapple with in the next year. If this is possible with LTAC, that would be something I would be like open to hearing more information about, to answer more questions. But I think pretty categorically from the general fund, that is a pretty concerning prospect, I think, to really be approaching that $6 million figure for a deficit. So with that in mind, if LTAC seems viable, then I think it would be a good use of time to hear more from the chamber so that we can have a forum to pose those questions.
Thank you. Councilmember Kathy?
Yeah, I agree with many parts of what everybody has said. I wouldn't vote for it tonight. But what I want to say is, do we have to jump in with both feet to do this, or can we could we as a city say something that we're going to encourage our people to volunteer? Could we find out some of the volunteer areas that will be necessary, maybe on this end or whatever, and kind of maybe recruit people rather than pay to play or whatever. So anyway, that's just a thought, and it came to my mind when Kelly said that they volunteered at the golf tournament, as did my partner, because doctors are required to be on extra on site or extra staff in emergency room hospitals and things like that. So it really impacts the community to have a big thing like this come. So those are just my few thoughts. I think everybody had good input here. Good discussion.
Yeah, the topic of can we do parts and pieces of this, or is it all or nothing? That's definitely a question for the chamber. I would guess they would be happy if we would help something as opposed to nothing. But I wouldn't speak for them on that account. I can check with David Schaffert and Jenny and see if they are willing to come to a council meeting and answer that question, and also the question about what happens if Tumwater doesn't participate. What are the implications of that? Thank you. Appreciate that, Councilmember.
All right. So I think the next step is to get more information from them. It's hard to answer all these questions without having more information. So, and it feels like a moving target at this moment because they're still working on a lot of the details. So, all right, more to come. All right, so we'll move to the Mayor City Administrator report. I'll start out with City Administrator Parks.
Yes, let me pull up my notes here just real quick. If I can find them. I'm sorry, I'm gonna
I mean, if you don't have a report, it's almost 9 o'clock, Lisa. We trust you.
I
Okay.
think everybody's been having like a 3-hour. I don't think, other than I think you had a great 4th of July turnout. I think.
I mean, you don't have to. You can follow up with an email, Lisa.
Yeah, I can. 4th of July was a huge success, huge kudos. Screen on the Green is back, starts on July 18th at Toyota Center. Look on the website. The maintenance project, the 2025 pavement maintenance project has begun. So you will see people and the contractor out and about fixing our roads. And one important heads up, you may hear from constituents, 70% of the play structure at Pioneer Park had to be removed for safety reasons. That work was done on the 4th of July because the park was closed and not busy. And just know that that occurred, and the reason is safety reasons. There are other parks that are going to be faced with the same issue, and there are parks where we had to do the same thing just within the last couple of years as well. Last thing, the work session on the 22nd of July, we're asking that that be a hybrid format. So if some of you could please come to City Hall chambers, council chambers, if at all possible, that would be great. There we go. All done.
Great. And we will call it good. All right. So with that, I believe we are adjourned for the evening because Lisa covered most everything I was going to discuss. So have a nice evening. Thank you.